My name's Georgia Shriane and I work in the commercial team at HCR, and today I'm here to talk to you about data protection law. Data protection remains the subject of many inquiries from in-house lawyers and other clients, and as a result at HCR we've just launched a new HCR Data Flex service to provide a service that is tailored to our clients' needs and that covers all aspects of personal data compliance. This talk today is to update you on recent developments in data protection law and their consequences. So as a reminder to start with, one area that stays the same and hasn't changed is UK personal data transfers to Europe or other territories with an adequacy decision. The UK government has done nothing to put any hurdles in the way of those transfers post-Brexit. However, we do have some issues relating to EU personal data that might be transferred from the EU to the UK. This is the bridge, and the bridge refers to the agreement at the end of December, the treaty between the EU and the UK, which allows the continued transfer of personal data until an adequacy decision, we hope, is reached. So this bridge is in place until the end of June 2021, and on that basis, all businesses have been able to continue transferring their personal data to the EU and the EEA and to other territories with adequacy decisions. This means that organisations like yours have been able to continue those data transfers without any further agreements in place. Now we're hoping for an adequacy decision, as this would be the solution to the possible hurdles that might be put in place after the bridge ends at the end of June. So since February there's been a draft adequacy decision in place that has been prepared by the EU Commission, and if adopted, that decision will continue to allow the free flow of data from the EU to the UK. But it does require all 27 EU countries to sign it off. And this draft decision was referred to the European Data Protection Board, who have very recently, in fact last week, delivered their opinion on it. They made a few points. The first point was that they endorsed the draft overall on the basis that the UK data protection regime currently mirrors the EU GDPR. They also observed that the UK was unique in its status as having previously been an EU member and fully signed up and compliant with the GDPR. However, they have noted that the UK has made political noises to depart from the European GDPR regime and to develop its own independent data protection laws. And that would be particularly with a view to the transfers to, say, the US or other third countries, which currently are problematic under the GDPR. As a result of that political noise, the European Data Protection Board has concluded in their review and their advice to the EU Commission that they should continue to monitor the developments in the UK, and they have also welcomed the idea that they should include a sunset clause in their adequacy decision, and that would mean that the adequacy decision would stand for 4 years but would not automatically renew and could be cancelled if the UK diverges from the GDPR. So, what does adequacy mean? Adequacy is a term that the EU uses to describe other countries, territories, sectors, or international organisations that provide an essentially equivalent level of data protection to the GDPR. The effect of an adequacy decision is that all personal data can continue to transfer without any further safeguards being necessary. So that means that there are no need for standard contractual clauses or binding corporate arrangements or other formalities that would usually be required for restrictive transfers. What does stay the same, though, whether or not there is an adequacy decision granted, is the need for a European representative under Article 27 of the GDPR. So Article 27 says that an organisation must appoint a representative in the EU if, being a UK-based controller or processor, you have no offices, branches or other establishments in the EEA, but you are offering goods or services to individuals in the EEA, or perhaps monitoring behaviour of individuals in the EEA. So the question is really, what is an establishment? And an establishment has been very broadly defined. An establishment could be an individual who is permanently employed in the EEA and works for your organisation, or it could be a registered company or another entity. That is the first step. If you don't have any establishment, office or branch, then you need to authorise a representative in writing to act on your business's behalf regarding your EU GDPR data compliance. And they will deal with the local supervisory board on your behalf, but they do not take the liability. Your UK-based company remains liable for compliance. The details of your appointed representative should appear in your policy and should be widely available to all third parties, especially EEA-based consumers. You do not need a representative if your processing of EEA data is very occasional only, and if it is very low risk, and if it doesn't refer to any special category data. So if there's a one-off occasional transfer, then you don't need an Article 27 rep for that. The same, of course, applies the other way around for European companies who trade directly into the UK. They will need a representative in the UK. So a new concern that we've recently been advising on is the cut-off date and idea of frozen data. This is because any European personal data that was collected before the 1st of January 2021 must continue to be processed under the European GDPR, whatever other regime might be introduced in the UK. So we need to create a frozen cut-off date, a second database. Personal data that's collected after the 1st of January 2021 will then be governed by the UK GDPR, and if we carry on diverging from that regime, then we might need to establish a separate database at a frozen cut-off date there as well. So the point is that the date at which the personal data is collected is the freezing date, if you like. That is the date that is crucial for which regime applies. Another just side point is that we are still waiting for PECA, that's the e-marketing regulations, to be updated by the EU. So my final point now is considering the American issue and other third countries, and I will just remind you what that issue actually is. So that is the point that Privacy Shield has been held by the European courts in July 2020 not to provide adequate protection for European personal data, and therefore we can no longer transfer UK or European data to the US because any data transfer of that type is effectively non-compliant with the GDPR. And yet we continue to need to transfer that US data. Why did this decision occur in the European courts? Well, it's a very simple and quite a fundamental principle that in the EEA and in the UK, the governments do not have an overriding right to monitor or surveil electronic communications, whereas in the US, there is a right that is the state's right, and that has primacy, that allows them to surveil for national interest any electronic communication. So there is a fundamental conflict there. And previously we thought that a transfer under Privacy Shield would protect GDPR sufficiently, but what we know now is that actually Privacy Shield does not set aside the US's state right, and therefore even with Privacy Shield that covers all the other technical or organizational security measures that might be required, it doesn't prevent the US state from intervening, and so that's considered non-compliant. So how can we then transfer personal data to the US? Well, that depends very much on what the category of personal data is. If it is commercial personal data, i.e. your client who wants you to fulfill a contract in the US, then they will need you, by definition, to provide their data to the US. And on that contractual basis, you may be able to make that transfer. Certainly, if there's any doubt, you can obtain their consent to that transfer. So that is one way to make that transfer to the US compliant. In obtaining the consent, you would need to tell them exactly what the transfer of data is going to be and to whom you're going to transfer it. The problem, though, that arises for a lot of our clients is actually that they are needing to transfer, or they are in the habit of transferring, their employee personal data. And the issue with the employee personal data is that due to their employment relationship, they can't give the free consent that your client might be able to give. So this has led to, for example, a number of UK subsidiary companies who have a US parent setting up an entirely separate HR system, including the storage, obviously, for the personal data in the UK, so that they can manage all European or UK-based personal data in the UK and not make the transfer to the US. This is obviously not always convenient and also quite expensive. but it remains the only real compliant way to manage this. If you are an employee in the UK working directly for a US company and being paid by your US company, that may be the exception, because you need to transfer a certain amount of data to be paid as part of your employment contract. However, if you're employed by the UK subsidiary, there's no need, and therefore that data transfer shouldn't take place. What about other third countries who also don't have an adequacy decision? Well, that would be a restricted transfer, as we've discussed earlier, and that would need a standard contractual clause or binding corporate rules to be in place, and that should enable the personal data to be transferred safely and compliantly. But applying the same principle as Privacy Shield in the US decision, what is actually necessary is to consider the overall regime in the territory and consider whether there are rules such as the US's primacy laws that prevent you from safeguarding that personal data, even with standard contractual clause or a binding corporate rule agreement. So we do have an interesting point to watch, which is this sort of three-way collision that seems to be happening on personal data and digital transfers, which is this conflict between the GDPR and the US system, and the UK at the moment sort of floating between the two, promising that they might enter into new agreements with the US, but obviously wanting to retain the adequacy decision from Europe, and therefore a sort of uncomfortable situation where we wait to see what the outcome may be. In the meantime, the US are also negotiating with the EEA to agree for personal data transfer to continue there, and really it's unknown at the moment. We await that outcome. So before I leave you, my key takeaways for you are, first of all, to consider whether you need an Article 27 representative. Also to consider the frozen cut-off date and the management of your databases going forward. And then finally, if you're interested in the HCR DataFlex services, please contact me. Thank you.